Well, good afternoon to all. Thank you for joining us today. And I guess I'd like to begin by thanking both Professor Giora Binder and Professor Eko Yanka for agreeing on such short notice to join us for this conversation, really, on George Floyd, policing, race, and the trial of Derek Chauvin. I'd also like to extend our thanks to our Dean, Aviva Abramovsky, for all that she has done with regard to furthering initiatives regarding diversity, equity, and inclusion at the law school and in the broader university community. Much has been done in that regard in the last couple of years at the law school, and this event is one more of these events that show our continued commitment to advancing diversity, equity, and inclusion issues. So thank you to Dean Abramovsky. And then now let me just begin with the ground rules for the conversation, and then we'll start the conversation. So the ground rules are: we will set aside approximately 20 minutes or so for Q&A with the audience. If a member of the audience wishes to ask a question, please submit your written questions using the Q&A feature in your Zoom program. The chat feature of the Zoom program is disabled for today's conversation, so there's no need to use it. And in terms of the structure of the conversation, we have agreed to try, to the extent that it is possible, to have a more free-ranging, informal conversation about many of the issues raised by this case, as opposed to having a more structured or stuffy, formal question followed by answered by question. So we acknowledge that it is challenging to try and recreate that environment by Zoom. And the three of us will do the best we can to try and do that. So that said, we are going to devote a portion of our 40 minutes or so to discuss the so-called legal issues related to the case, and then we'll discuss the other then during the other half or so, we will talk about some broader implications raised by this case and by George Floyd's murder. And those broader implications are philosophical, political, moral, etc. And we will get to some of those during the second half of this conversation. So again, thank you all for joining, and let's begin. So I would like to begin by asking my friends, Professor Binder and Yanka, a little bit about the charges in this case. Many people in our audience are not from the law school. Many are, but some are not. So some people may not be totally familiar with the differences between the offenses charged. So with that in mind, then we have a couple of murder offenses and a manslaughter offense that Chauvin was charged with. And I will then give the floor to my friend, Professor Binder, who will briefly tell us a little bit more about the charges against Chauvin.
Okay, so greetings to all of you. Before proceeding further, I want to take a moment just to acknowledge and thank a research assistant who assisted both myself and Professor Yanka in preparing for this, and indeed she's been working for us on some joint research we've undertaken on felony murder, and that's Shakira Smith here at UB Law School. So thanks very much for her excellent work. So next, I want to say just a little bit about two charges that are not being brought in this case, right? So one would be first-degree murder, which would require premeditation, premeditated intent to kill. So that was not charged in this case, nor was second-degree murder charged in the form of intentional killing, right? So there are two different forms of second-degree murder that might have been charged here. One would be intentional killing, but that was not charged. Instead, what was charged was a form of felony murder, a term that that you've all heard and that is not so easy to explain. But it's causing death in the course of certain felonies. In this case, the predicate felony is a form of aggravated assault. So basically causing injury to someone, which, as we'll explain maybe in a bit, is an unusual predicate for felony murder. A second charge brought in this case is third-degree murder, which is a crime that's punished in most states around the country, sometimes called depraved indifference murder. And so it requires that someone cause death with reckless indifference to human life. And in Minnesota, it requires that it be an eminently dangerous act that's performed with reckless indifference to human life. In many states, this charge is conditioned on endangering multiple potential victims. And that was how it was understood in Minnesota up until very recently. In fact, during the litigation of the Chauvin case, this changed as a result of a decision in another case in which police had killed a civilian. So now it does not require multiple victims, and for that reason, the third-degree murder charge, which had been dropped, was reinstated against Derek Chauvin. And then finally, we have a second-degree manslaughter charge. This involves causing death with culpable negligence, and in the Minnesota context, that means while consciously risking at least a great bodily injury. So those are the charges in this case.
Thank you. Echo, I don't know if you have, and I'm just going to go first name here to help with the informal nature of this. So I don't know if you have anything to add with regard to the charges. I'm okay to move on, but I don't know if there's anything you want to highlight before.
No, I think Giora typically has done a great job. I would only say, well, for those who really wonder, why would you have a kind of depraved heart murder need to risk multiple lives? And there could be some debate about that, but part of it might be you want the kind of dangerous activity that literally endangers groups of people. But part of it was also that the long history of depraved heart murder, not always, right, but often, was a kind of indifference also to even the identity of the victim, right? So if you're teaching the classic depraved heart murder, what would it be? Firing randomly into a crowd or throwing a boulder off an overpass, right? So it wasn't always just the idea. I mean, another classic case law professors choose is spinning a loaded gun with one bullet and aiming at one person. That looks like it only endangers one person. So that's also depraved heart death if the bullet fires. But so often these depraved heart deaths, it's not just that they threatened large groups of people, it's that they see the kind of classic idea is they threatened groups of people indiscriminately. And so that's part of the tension that Giora was mentioning. But because you can also have cases where I'm aiming a gun that may or may not be loaded at Luis, God forbid, right? The Minnesota Supreme Court then the Minnesota courts then looked at another case and pointed out that there's also a long history of depraved heart murders where there was only one person in danger, but in indifference to that one person's life. So that's just a little extra fleshing out. And if Giora objects to that encapsulation, he should let me know.
So it seems like Giora's okay with that encapsulation of it. I guess just one quick follow-up before we move to another topic would be, how settled is this new interpretation of the murder statute? So are we confident that that's fully settled for this case?
So I'm going to take a stab at this, not being somebody who practices in Minnesota. I mean, so maybe for once it's helpful that I actually did give a little extra law professor history. On the one hand, if you had asked me, well, look, in the middle of your trial with your defendant or your prosecution, this new ruling comes out, which now locks in this definition of depraved heart. How settled is it? You would think, I mean, it's a new ruling, it's good law, but you've got reason to strain against it. And for those in the audience who aren't lawyers, there are even some legal arguments about whether or not somebody should be tried when there's a change of law as they're being tried. So those are often, for civil procedural reasons, serious and important arguments. I think here, this is a gut instinct. I think it's pretty settled precisely for the reason I just mentioned. Notwithstanding that often depraved heart murder was about aiming at a group of people indiscriminately, there's a long line, a long tradition of being indiscriminate about a single person's life, right? So the classic is a case called Malone. It's a well-known case. It's a child, two young people where a child is essentially playing Russian roulette with another child. The details are a little more complicated, but I'll set them aside. And the gun goes off. And the one who's now killed his friend says, "Are you okay?" That is such a well-known strain of putting one person in danger that I would be surprised if the defense counsel decided to attack this interpretation, because it's, there's a rich enough history that it doesn't strike me as odd or unstable, as you put it.
A similar development took place in New York, where it was, long understood that this was primarily about putting multiple people at risk, and then there were a couple of cases that involved a single victim who was sort of put in danger by an attack, and then sort of left to die or left in danger. In one case, drowning; in one case, getting run over by traffic. So this has kind of been the trend in the law generally, that with sufficient indifference, cruelty, depraved heart murder for a single victim is a possibility. So now, Luis, do you want us to talk any more about the felony murder charge here? Or?
Yeah, I know. I did mention that I wanted to do that. No, I very quickly, I when I first saw it, I mean, now I've researched it, but when I first saw the charges, the first thing that popped to my mind as a criminal law professor is, well, that's a weird predicate felony on which to base the second-degree murder charge. And just felony murder in general seems a little bit interesting. But I'm going to bracket that, assuming that they did go with felony murder. And what made it weird, and I'll just throw this out there, and then Giora will have the difficult task to explain this to an audience comprised partially of lay people, is that when I saw the predicate felony being an aggravated assault, I said, oh, this triggers potentially something called in some jurisdictions and applied called the merger doctrine, where you wouldn't be able, I'll just say you wouldn't be able to use that kind of predicate offense to generate felony murder liability. So I'm just curious as to your thoughts as to this in Minnesota.
Sure. So yes, it's Minnesota's in the minority in allowing this kind of offense as a predicate. Interestingly, one of the few other states that does this is Georgia, where there have also been some prosecutions in one case police, in another case vigilantes purporting to do a citizen's arrest, on high profile prosecutions for killing of Black victims. And so in those cases also, aggravated assault was the predicate felony. So this is unusual. In most jurisdictions, predicate felonies are just sort of enumerated in a list. Usually robbery, burglary, rape, arson, sometimes escape and kidnapping are the main ones. And usually they do not include sort of a simple, beating or assault, that is intended to injure, that injures somebody. And the idea is that that conduct where you don't intend to kill, but you set out to hurt somebody or injure them is ordinarily manslaughter. It's sort of textbook manslaughter. And so it kind of collapses the attempt to grade homicide at different levels. If you do this instead, you want to use a predicate felony that involves some other bad goal, stealing or sexually, violating someone's sexual autonomy. And it's sort of the indifference shown in doing that put them together. You get some kind of serious liability. Now, the other thing we want to say is most law professors, most progressives, disapprove of felony murder liability altogether, right? So one of the interesting things about this case, one of the troubling things about this case is it pulls, in this respect, it pulls us in two directions. It's, very important that police, when they kill without justification, are, prosecuted the same as anybody else. On the other hand, we have this feature that's distinctive in American criminal jurisprudence that imposes murder liability without intent to kill or even necessarily recklessness. And, that's the path that looks like, is being taken in several of these high profile prosecutions. So that's troubling. And actually Echo and I have been talking about this and writing about this, and I'm going to pass it over to Echo now. So Echo, what do you think about this?
Let me first say this is terribly unfair to actually follow somebody who literally wrote the book on felony murder. And I'm not saying this in this sort of turn of phrase, in that Giora has written the best book on felony murder available. And so Giora is exactly right. Now, here's something that's actually delightful. Giora has a picture, for those of you who can notice it in the background, of Franz Kafka, I believe. Is that right, Giora? And I point that out not accidentally, because explaining felony murder to people does give you this Kafkaesque feeling. It really can make your head explode. And so Giora has tried to capture it. I'm gonna say it as simply as I can to make people understand why it feels head exploding. So as Giora said, look, you get punished for felony murder when you didn't intend to kill somebody, right? Why is that? Well, there are real explanations, and I take up Giora's invitation. A lot of progressives and a lot of law professors, and myself included, have either entirely opposition to felony murder or at least deep reservations. And I think Giora even counts as a person with real reservations. But what is the counter argument for felony murder? It's straightforward. Look, Luis, Giora, and I decide to set fire to a house to collect insurance, right? What we don't know, and remember, we don't know this, is that there's a child sleeping in the basement, right? We just wanted the insurance money. And so we say, look, when we're prosecuted, you can't prosecute us for murder. You can prosecute us for a lot of other things like manslaughter, recklessly killing somebody, but we didn't intend to kill somebody. What's the counter argument? Here's the powerful moral counter argument. We knew it was dangerous. Maybe Giora, Luis, and Echo didn't know, but the rest of us have known it's dangerous. That's why we've said don't set fire to houses, right? We have told you that some set of felonies are so dangerous that they're often going to kill people. And when you walk around saying, oh, how could I have known? We have every right to say, because we told you so, right? That child's parent is going to look us in the eye and say, explain to me why this isn't as good as murder, when we've told people if you commit a bank robbery, somebody might get killed. That's the fundamental impulse behind felony murder. You did something so dangerous that we don't want to hear you say. I mean, it's the kind of thing you say to a child when your kid says, but it was an accident. How could I have seen it coming? The answer is because I've told you 100 times, if you do this, your brother's going to get hurt. That's the kind of impulse. But then what then is this merger rule? What's the problem here? Well, the problem now is when you actually do something that might kill somebody, Now you can't use felony murder. Wait, I'm confused. Wait. If I do something that doesn't intend to kill somebody, you can charge me for felony murder. But if I do something that intends to kill somebody, you can't. Why would that be? And then this is the kind of argument lawyers find very important, and we have to make it real to people. If I aim a weapon at Giora and I shoot at him, but the reason I do it is because I am insane or going through some sort of crisis or intoxicated. I know the Kafka picture is coming to life. So I'm arguing that I have some mens rea defense. Something has gone wrong that makes me...
Actually, I was just ducking your aim, but...
Right. So now I'm arguing that, there is something about me. I'm under some sort of psychological distress, and I want to present that to the jury. I want my fellow citizens to know that something was wrong with my mens rea, my mental state. That means the state can't call me a murderer. The prosecutor says, that's complicated. That's hard. You're going to confuse the jury. I'll tell you what I'll do. I'll just charge you for unlawful discharge of a weapon, because there's no mens rea defense to that, right? The problem is, in this world with so much criminal prosecution, a prosecutor can always find a crime that came beforehand. A prosecutor can always find driving dangerously or discharge of a weapon, or as Giora said, assault, right? If we just say, well, you assaulted him, that's a felony, and we're going to bootstrap murder onto that, nobody will ever be able to argue their mens rea defenses, because a prosecutor will just look around and find the closest felony and use that. And so that's the problem. When if you say Derek Chauvin didn't intend to kill him, but will find a crime in the neighborhood and use that, then the state will always have the power to charge almost any. Let me assure you, there is no competent prosecutor that cannot find some felony, and the state will always be able to charge murder. And that is an awesome power to give the state. So Giora is exactly right. It's our intuition. We want to get this guy. Chauvin deserves to go up for whatever we can get him for, as against our knowledge that giving the state this kind of power is dangerous and frankly often used against people of color. And so we should be careful how much power we give. So that's one way of trying to capture this weird tension.
Thank you, Echo. I'm going to move on, but before moving on, I'm going to take the privilege of being the self-appointed moderator and try and convey the idea of murder and the problem with murder in this way. So the way I see it, one problem, it's not the problem, but one problem with using assault as a predicate felony for murder, felony murder, is that a bunch of homicides are actually take place as a result of an assault that took place. And then if you turn assaults into murders, this eviscerates the kinds of grading distinctions that Giora was talking about, right? Because if there's one place in American criminal law where we've really tried to make distinctions based on culpability and mental state, it's homicide offenses, with murder and different grades of murder, and homicide or manslaughter and different grades of that, as we even see in this case. And the problem is, and I'm just going to make this number up, but imagine that of homicides, 75% include some assault, before the homicide. Then it would turn out that most homicides would be murder, and by operation of a felony murder will wait on assault. Right?
Oh, it would be murder. Right?
Yes.
There is no ambitious prosecutor who could not. I mean,
right.
Look, both of your explanations are helpful. The next time I teach felony murder, I will tell you, I teach felony murder every year. I've done so now for over a decade. I'm aging faster than I'd like. It is worth pointing out that it's taken 3 law professors to turn the facet each time to try to make people see, because it is not something that reads intuitively, which is among the reasons we ought to worry about it, that it is it's non-intuitive, incredibly muscular power for prosecutors.
Well, so we do have a question here that I'm going to already use as a springboard for this next topic that I want to discuss which is the causation question, and in part, and the use of force question. We can talk about both during the next 10 minutes or so. I'll start somewhat provocatively, although perhaps this won't be provocative for you guys. But when I taught law enforcement, authority in class, my criminal law class here at Buffalo a week or two ago, Obviously, we talked about the Derek Chauvin case, and my line was something like, this case isn't legally interesting. Like in terms of the criminal law, like this is a sort of like a slam dunk. I think the causation thing is sort of bogus for reasons that I think we will discuss, and let's see if you agree with me or not. And the use of force arguments seem pretty weak sauce to me too. So in general, what I see here, and frankly, what I see in many, if not most of these cases involving police officers who shoot unarmed black males, is clear liability, clear grounds for criminal liability, but that tends not to materialize for reasons that go well beyond the substantive criminal law. Right? So that's my view. I'd like to hear your thoughts on, again, with regard to causation. I'll just remind the audience, the defense is arguing that the actual cause of death was not the use of force used by the police, but rather drugs in the system, some combination of fentanyl and meth. And of course, this has its own sordid history regarding painting black males as out of control, body full of drugs. So it fits with certain stereotypes and tropes that's also part of the conversation. But the defense is arguing that with regard to causation and with regard to use of force, that it was justified, that it was reasonable. So any thoughts on the defense's defense?
So I'm going to separate the two issues of causation and use of force. Causation, I agree with you. I don't see it as a super interesting, legally, as important and as the case is. But I think it's it's probably the crucial issue, in the sense that if the prosecution fails, it will be on this issue. It won't be on the use of force issue, which is surprising, because usually it's the opposite, right? So in a police shooting case, there's usually no issue about causation of death. It's victim was shot maybe often multiple times, because police are often trained to empty their weapons or keep shooting until they're sure that they're safe. And then it's sort of but in a shooting case, police will often be able to say, oh, I thought I saw a gun, a threatening gesture. I had to make a split-second decision, and those arguments often are persuasive to juries and the other decision makers. Here, it's quite different, right? So it's though there are a number of cases where victims die in police hands, as a result of use of force that is not, a gunshot, right? So, so the conventional causation analysis in most places, in most jurisdictions, is there's sort of two questions. One is, was the defendant's act necessary to resulting death, such that if Chauvin hadn't done what he did, Floyd would be alive today. And then sort of a second level is, okay, so was the result foreseeable, or as a result of his actions, or was it fluky? And then a third issue is, was there some other necessary condition that was subsequent to his action and that was independent of it, right? Now, what's a little different in Minnesota is they don't require that the act be a necessary condition. They just require that it be a substantial cause or substantial factor in the death. Now, this doesn't necessarily mean something different from that, but on both analyses, you can have multiple causes of death. You can have multiple necessary conditions, right? So, Echo shoots me, and I don't duck. Both are necessary conditions to the resulting death. And so here the main defense allegation is that it was, that the drug, there was a heart attack. That was the, that was the, necessary to the death, and with some intimation that the heart attack was caused in part by drugs. But if even if there was a heart attack and it was caused by being choked, by the stress of being choked, that could be a cause of death in Minnesota. In any case, the defense witness, the main defense expert, probably lost a lot of credibility for his claims when he suggested that a possible cause of death was carbon monoxide poisoning, which obviously didn't kill any of the other people present. But that seems to have been pretty well devastated on rebuttal by the medical examiner who was recalled. So that's causation. I'm going to maybe turn over to Echo. Maybe Echo wants to talk a little bit about the use of force problem, or I think causation.
I think Gura's got it exactly right. But what you want to notice is that this is a two-stage kind of argument for the reasons Gura's already hinted at, right? So look, I mean, one thing I want to say, if there's something to be said for the defense, it is that they are, after all, his defense team, right? They have to have an argument. And let's be honest, if this is your defendant and this is the evidence in front of you, a video of him kneeling on his neck, I mean, what is left, right? I mean, the only thing you're going to argue really is that these other things killed him, right? I mean, if you've decided not to plea out, right? Which, anyway, if your client refuses to take some sort of plea, this is where you are. So, and I want to say that, we should remember that there are really profound reasons to be dedicated to the idea that everyone deserves a defense. So here we are, you're his defense team. You're going to go for causation. The argument is twofold in the way Giora has already indicated, right? So you have to have caused the death. That's the only real argument they're going to have. If you can convince the jury, did I say the jury? No, let's be really honest. If you can convince a juror, that's what the defense counsel is going for. Look, they need one person to have the faith that this is not what one or two people who are willing to stand throughout the deliberations, and that's enough to acquit your defendant. That's their job. So if they can convince one or two people that something else killed killed George Floyd, then they'll get the acquittal. As Giora pointed out, they don't have to prove, the prosecution doesn't have to prove this is the only thing that killed him. They have to prove that it's a substantial cause. The classic kind of case is, you slip drugs into somebody's drink. They've also taken a bunch of drugs, and the mix of them kill them, right? If you can say, look, they were going to die from all the drugs they'd taken anyway, or if you can prove, again, did I say prove? No, that's not this burden, right? If you can introduce reasonable doubt into one jury's mind that all the rest of the drugs killed them, right? Then that's to say you weren't a substantial cause. Unfortunately, in the classic cases where you have to be a substantial cause, if your drug was part of what killed them, that's enough. And that's what the defense is facing. Astute listeners will notice, and the summation is happening even as we speak, that defense counsel, like any lawyer, is not going to leave things as clean as all that. So even as the defense spoke, they said, the state has tried to prove to you that the knee is the only thing that killed George Floyd. If they can't prove that the knee is the only thing that killed George Floyd, then we win. And they know that's not the instruction, right? But they want to make it seem as tense as possible, right? They are, I'm not going to go so far as to say they're misleading, but they're really, well, maybe they're misleading, right? Maybe I should go that. I mean, they are, like most defense counsel, making the state's burden seem even higher than it is. The reason that's all related to the use of force is because the closer and more obvious Derek Chauvin's force is to purely unreasonable, the more often the law says you take your victim as you find them, right? We call it in tort law the eggshell plaintiff. There's an equivalent in criminal law. It's not exactly the same, but you see strains of that in criminal law. If I throw something unlawfully at Luis, if I throw a punch unlawfully at Luis, he then falls down and hits his head, and 3 days later he has an aneurysm, right? The law is more likely going to find me liable for having caused it, even through these kind of complicated set of effects. Remember, Luis was also drinking in those 3 days. He was doing drugs in those 3 days. He was all these other, the unlawfulness of the force often influences the way the law draws causation. This is not an easy thing to explain, but there's sort of a relationship between those two things. So the defense has a two-step argument. One, the force was not that unlawful, or was not unlawful, it was reasonable, is what a reasonable police officer would do. And two, these other things killed him. Those things go hand in hand. But the last thing I want to say, forgive the long-windedness, is I want to circle back to pointing out with Luis that ultimately this case is interesting because of what it means, what it stands for, and its political ramifications. If instead of being a law professor, I was something remarkably useful and well compensated, like a computer programmer, if I could magically go into that video and take off Chauvin's uniform and show the world a video of two civilians in a fight where somebody put a knee on somebody else's neck for 9 minutes, there'd be nobody in the world would think there's a serious doubt if you're a substantial cause of death. The case would be over, right? It is precisely because police officers are treated differently, sometimes for good reasons, right? They're authorized to do things that the rest of us are not, right? But when they're not being authorized, they're supposed to be treated just like you and I. That we know is not the case. So we shouldn't pretend that it's not the rich and swirling social and political grounds that make this, in turn, legally a hard case. As Luis said, it's not the actual facts on the ground.
So, yeah, Gira, we're running late as usual.
Yeah. So I just wanted to sort of spend a minute or two on the use of force issue. We all see it as a very easy case for the prosecution, but that's sort of interesting and a little unusual in these cases. In part, of course, because of really the posture of the prosecution. I think they're serious about this one. Often prosecutors are going through the motions in these cases. The test, that the jury will be given in this case is simply what a reasonable officer in the same situation would believe necessary. So if what Derek Chauvin did is not what a reasonable officer in the same situation would believe necessary, his use of force was unreasonable. If, on the other hand, the jury thinks that his use of force by that test was reasonable, or rather, I should say, it's the prosecution's burden to prove that his conduct was unreasonable, was not what a reasonable officer in the same situation would believe necessary. Burden of proof on this issue of justification is on the prosecution everywhere, and that's largely by design. That's because the main beneficiaries of justification defenses are police officers, right? So it's not because legislatures who write codes are sort of pro-defendant and want to get them off. It's they want to be seen as tough on crime, but they also want to be seen as friendly to police. Here, the prosecution's put on a very strong case that Derek Chauvin violated department policy, violated his training, and so that makes it pretty easy for the prosecution on this issue. But that is it's often much more difficult, and there's So, many of the cases we're most interested in, we most follow are shooting cases, and in those cases, it often turns out that department policy is not so good. That police are encouraged to shoot if they have any doubt that they're safe, if they have if they believe that the victim has a gun and might shoot them, even if that belief is incorrect. Juries are often instructed that based on language from a Supreme Court decision, that officers have to make split-second decisions, and that jurors should not judge the reasonableness of their actions by 20/20 hindsight. Again, using phrases from a Supreme Court case, Graham v. Connor. So this is in cases with different facts, police training actually, and police mistraining, bad training that encourages police to use force when they should not, actually then has the effect of insulating police from liability, because it means that their defense attorneys can come on and say, oh, look, their conduct was consistent with their training, right? The more they're encouraged to use force by their departments, the less likely they are to be successfully prosecuted.
Yeah, but this rushes us headlong into some of the conversation, Luis, I'm sure you wanted us to have, and happily tramples all these boundaries, because part of the question here, of course, is about what this case means in terms of policing generally. And here I could speak at length, but I won't. I'll say something just straightforward, because Gura is right about this, of course. One of the stunning things about watching the closing was, of course, defense counsel trying to make the argument that Chauvin was following his training. And indeed, the witness they most referenced, not surprisingly, is the person who trained Derek Chauvin, the person who said, you're allowed to do this, that I've trained him to use the knee up to the shoulder and neck. I've trained him to cut off air from both. And it went on and on like this. And I think one kind of thing that is sane polity, right, that we as citizens, I know a lot of people, a lot of my thoughtful colleagues think trials are shows, right? Trials are actually bad for us because they don't show the guts of the criminal law system. But one of the good things about trials is we ought to think hard about the fact that the justification for this kind of policing is too often, this is what you're trained to do. As I hear that summation, the only thought I had in my mind is, this is crazy. If your defense is this is how we're trained to treat fellow citizens, that's an indictment, not a defense. But only in our world, right, is that a defense of police behavior. And frankly, the prosecution didn't take that part on. They took on whether or not that this action met his training. But the prosecution, as most prosecutions are, was very shy about taking this on. Indeed, utterly refuted the idea that they're taking this on as taking on policing in general, right? So indeed, the greater political conversation about this case is one that is bracketed off stage.
Thank you for that, Echo. And I have to be clear for everyone, I obviously have stuff to say about all of this, but we have to keep it moving. So I'll keep it moving, and I'll abstain from saying what I want to say about what was just said. But what I will say, though, is that one thing that we haven't discussed, but Echo just began that conversation, was to talk about the extra legal stuff that's really doing most of the work, and or extra legal issues that are salient in this case, or that this case brings to the fore, or that presents us with paradoxes or potential contradictions. And in that, and I also wanted to say that we only have 15 minutes. We've taken a couple of questions already just by virtue of our conversation, because there were questions on causation and there were questions on the use of force. So we already answered those, but there's some that unfortunately we may not get to. But one of the questions I think can tee up a conversation that I would really want us to have, if only for like 5 minutes or so. And it's this question by Professor O'Rourke here at Buffalo, who, and I'll just read it. He says, Kate Levine and other abolitionists argue that using the criminal law to address police violence replicates the racial pathologies of criminal law and does little to address the systemic problem of racialized policing. What are your thoughts on this argument, and especially as applied to this trial? And let me just say that this is one thing that when Echo Giora and I were, emailing each other, this came up, like the tension between activists on the left, including Black Lives Matter, but broader coalition, asking for defunding or abolishing, the police or criminal law or punishment or some variation. And at the same time, seeing a lot of members of those same constituencies, yours truly kind of included. I am very much in my most recent years flirting with more abolitionist perspectives. And actually, that's the direction I see myself going in right now. And I feel personally the tension, because I when I teach criminal law, I'm always advocating for less criminal law and less punishment. But then I find myself with this case, and I want to see first-degree murder, not second. I want to see first, which wasn't even charged, which we can talk about, but we won't perhaps. But so any thoughts on that question?
Yeah, so I mean, look, Professor Levine is my colleague here at Cardozo. Professor McLeod at Georgetown. I mean, there's a slew. Alexa Hogue. I mean, there are a slew of very powerful voices. I mean, Angela Davis, most historically important. We should be conscious of her long contribution to this conversation. And so, look, we're all deeply sympathetic to the claim, and I take the point. The point Kate Levine made it most recently in an article is, if part of the argument is that Black communities are over-policed, and this is the way in which this policing exhibits itself in violence, then there's something very strange about thinking that that same tool, the over-policing in criminal law, will be the thing to solve this problem. And put really plainly, it falls into a sort of supportive, as Kate Levine would argue, pathology. What's that supportive pathology? If you think criminal law solves the problem, then you're just looking at Derek Chauvin. It makes easy the one bad apple kind of argument, right? All that's gone wrong here is that this cop has done something wrong. If we put him in jail, we'll fix the problem. That was shown today, those who watched the closing statement earlier today, when the prosecution more or less said, this is not an anti-policing prosecution. This is a pro-policing prosecution, right? Why? Because we're throwing the bad apple out of the otherwise good police. And this doesn't speak to not just the defund the police movement or Kate Levine, my much admired colleague, or this professor that let's be more honest. There is no point, especially in the African-American experience, where you can read literature from African-American thinkers of their generation that does not focus on systemic police abuse, right? If you want to go back to Ta-Nehisi Coates of this generation, James Baldwin of the last, King of the same, Booker, Frederick Douglass, the founding of, there is no point at which the systematic violence and over-policing of Black communities has not been addressed as a systematic problem. And so there's this worry that trying to pretend that if you just prosecute this one guy, you'll solve the problem that's the argument, feeds into that. I'm sympathetic to that. Look, I fully agree with my abolitionist colleagues. I don't count myself as among them, but I fully agree with my abolitionist colleagues that if we want to solve the most fundamental problems in that face Black communities, indeed the ones that we try to address with the criminal law, we would address them the way we've addressed them in white communities forever, right? With pro-social movements, with investments in community. When white people suffered from an opioid addiction that's the largest epidemic we've ever seen, we turned to rehabilitation, drug treatment, and we've de-emphasized policing. When Black people suffered from a drug addiction, we militarized our police, right? When white people suffered from unbelievable poverty in the Lower East Side, we built whole structures in America. We invented the weekend, right? We didn't try to police ourselves out of these deep social problems. And so I'm entirely in agreement with that. With that being said, I still think that certain forms of human violence and cruelty are probably conditions of the parts of the human condition, and that the criminal law will always have to respond to them. And so I'm wholly in agreement that the idea that we can look, we can't police our way out of the most serious social problems, and we can't police or arrest or prosecute our way out of racism. But that doesn't mean there's no role for the criminal law to play in repudiating racist violence. And so I think we have to be able to do both.
I have thoughts about that, but I'll go to the questions. So let me see. So let me ask about reasonableness, which was asked in the questions. It's come up several. So what I'm doing is I'm taking the questions impressionistically and trying to distill some commonality so we can talk about those. So let's talk a little bit, now that we're talking about the sort of extra legal implications, let's talk about reasonableness and how, about an hour or two before the panel, Giora emailed us the jury instruction for use of force. And it was, in my view, like incredibly unhelpful. It just repeated the circular, saying what a reasonable peace officer would do under the circumstances. But of course, the worry here is that reasonableness can serve as a vehicle for all of these, systemic prejudices and biases and all of these issues that we're seeing in our society to find their way into law enforcement authority, whatever doctrine it is. So I don't know if you have any thoughts on this problem and what to do about it, how it applies here, etc.
Yeah, so that's right. It's a very circular, as it were, instruction. It just says that use of force is justified if it's reasonable, and it's reasonable if a reasonable officer in the same situation would believe that it was necessary to use this level of force. So it's and so in general, in law school, we across many subjects where reasonableness standards are used, we tend to present that to our students as really an invitation to the jury, if it in a jury trial, to exercise its own judgment. And so we will often put that in terms of moral judgment, but the jury is also understood to sort of represent kind of community custom or mores, and such community custom and mores is majoritarian, right? And the composition of the jury historically in the U.S. has been contested. There are in criminal law cases, systematic efforts to keep members of minority groups off of juries. And while that's sort of illegal, proving that it's been done is almost impossible. And so it's done routinely, and in any case, juries are majoritarian. In this context, as we've said, what the reasonableness standard typically means in practice is that if you can say this is how the officers in this department have been trained, then that gives content to the idea of the response of a reasonable officer in the same situation. Reasonable just meaning average, and so as I said, bad policies, bad training can then absolve individuals. And there's even sort of an incentive to make the training as, in this sense, as bad as possible. So as to give officers the greatest protection possible. There, sort of the politics of criminal justice all pushes in that direction. Police are well organized. They're very influential in local elections. And so, it's everyone's incentives align to sort of train police to use more force than necessary?
So let me just complain about this for a minute, and then I'll see if Echo has not complain about anything you said, but complain about the state of affairs here. And it's that, this is just a pervasive problem in American law, and it reminds me, and both within and outside of criminal law, and it reminds me of an article that I really enjoyed, authored by a person that the three of us, that very important in our lives, George Fletcher, who was in one way or another, our teacher at some point in our lives, and he wrote this article in the Harvard Law Review titled "The Right and the Reasonable," where he sort of argued that in America, the sort of like organizing principle of law, was reasonableness, and in non-Anglo-American jurisdictions such as Germany or Spain, it would be what's right, the right versus the reasonable, and reasonableness is so central to American law, right, in the Fourth Amendment, and I hear what's being said regarding, well, what's reasonable is what's average. It's sort of like an empirical approach to reasonableness. But one would think that the best approach to reasonableness would be one that's not about what's average or about your training, but rather about what's right or appropriate or normatively reasonable, right? So I know that's kind of like an open question, but I find this frustrating and vague and ambiguous and not. So I'm just venting there. And the last thing I'll say about this is that I taught tort law. I don't know if either of you ever taught tort law way back when. And I remember that there was this question about custom and whether following whatever was customary, let's say in a given professional community, whether that was enough to establish that it was a malpractice. And some courts said the whole custom can be unreasonable, right? Which is what I would say about police. Like the whole training can be unreasonable. It doesn't really mean a lot, right? Anyway, I assume that you guys agree, but I just wanted to say that. We do have a couple, just literally 2 minutes. Yes.
I know we only have, but let me take up that invitation, because I think one of the things that's stunning is that your indictment doesn't even go far enough. Even among that which is custom, it is stunning how much we separate police. Look, I want to take a moment to say what we all say, and we all say it because it's true. Police have a hard job. It is a often dangerous job. It's not nearly as dangerous as sometimes the police would have us believe, but it's dangerous in particular ways. You are charged with going into situations most people do not want to go into. And indeed, of the abolitionist movement, almost all of that, I mean, the thoughtful abolitionist movement is, let's right-size police. Let's put police where they're needed. But let me put that aside for just a moment. One of the things that's really stunningly true is how often police behave in ways that would not be considered even averagely correct, right? So, we could just tell story after story after story about this, right? So, one of the stunning ones a colleague of mine wrote about recently was a very drunk man in Pittsburgh, I believe was. He's so drunk, he goes stumbling in and out of places he shouldn't be. The bar owner finally collects him and puts him outside. He goes to the wrong door, right? And he tries to put his key in the wrong door, right? And the homeowners are first scared, but then they realize what's happening. They calm him down and they point him towards the right door, right? And all this happens over and over and over until the police show up. A policeman sees him, he's drunk, he reaches for his keys, and the policeman shoots him dead, right? And the policeman has a real argument. This is reasonable policing. He reached for something, he didn't comply with demands, and so I fought. Here's what's interesting. Person after person after person among the ordinary population encountered this man, recognized he was drunk, recognized he was misbehaving, recognized he was confused, and they all managed to calibrate their behavior in ways that led him closer and closer to home. The police officer was trained to assume that everybody's going to try to kill you at any point and shot him dead. The police officer has an argument he was reasonable. To your point, it's not just that the police officer wasn't right, it's that it should be telling to us that every other normal citizen that encountered him did not think he was a lethal threat, or at least took enough time to read the situation and find out he was not a reasonable threat. We don't even require that of police officers. That's stunning.
So on that note, Echo, it's 4:00, and I just wanted to really thank both of you for what, I don't know how it felt subjectively to you, but for me it felt like a conversation we would have in person in one of our offices. It flowed nicely, and I want to thank you for your time. I know that we've been very busy end of the semester, COVID, and thank everyone who joined us as well. Obviously, this is just the tip of the iceberg. There's so much to say, so much more to say, and so many questions. I tried to touch on some of them, but it's difficult in an hour. But we didn't have a lot of time because of our obligations right now and everything else that's going on. But I also wanted to just very briefly say that I hope that everyone remains calm in the wake of the verdict, and if we need to protest, we go out and we protest, and we do what our heart and tells us that we ought to do. But this will be a difficult time for our country, but regardless of what happens, even if it's a conviction, for the most aggravated offense he was charged with, the work is only beginning with regard to policing and law, regardless of the outcome. So there's a lot more work to do, and we hope to be able to have many more conversations as we move forward. So thank you all for joining. Again, thank you, Yura. Thank you, Echo. And I want to thank as well Brandon and Lisa from the Law IT and the Law Communications Department for helping with logistics. So thank you very much to all. Have a great afternoon, and take care.